you doing? This is as far as it can go. Can you hear me? No. Is this, am I under arrest? Am I under arrest?
Transportation Code, Section 543.005, promise to appear, release, states, to secure release, the person arrested must make a written promise to appear in court by signing the written notice prepared by the arresting officer. The signature may be obtained on a duplicate form or on an electronic device capable of creating a copy of the signed notice. The arresting officer shall retain the paper or electronic original of the notice and deliver the copy of the notice to the person arrested. The officer shall then promptly release the person from custody. Section 543.006, time and place of appearance states, A. The time specified in the notice to appear must be at least 10 days after the date of arrest unless the person arrested demands an earlier hearing. B. The place specified in the notice to appear must be before a magistrate having jurisdiction of the offense who is in the municipality or county in which the offense is alleged to have been committed. Section 543.007, notice to appear, commercial vehicle or license states, a notice to appear issued to the operator of a commercial motor vehicle or holder of a commercial driver's license or commercial learner's permit for the violation of a law regulating the operation of vehicle on highways must contain the information required by department rule to comply with Chapter 522 and the Federal Commercial Motor Vehicle Safety Act of 1986, Title 49 U.S.C. Notice the word must contained in the paragraph. This word signifies that the officer has to ascertain as to whether or not an individual is operating as a CDL holder or actually operating a commercial motor vehicle.
Am I being detained?
This is how we were switched. DL14A Texas driver's license or identification card application. Application for driver's license class A, B, C, or M. Okay? Notice, the information on this application is required by the Texas Driver's License Act, Texas Transportation Code 521. 521. Section 521.083, Class C license states, a Class C driver's license authorizes the holder of the license to operate 1. A vehicle or combination of vehicles not described by Section 521.081 or 082, and 2. A vehicle with a gross vehicle weight rating of less than 26,000 pound towing a farm trailer with a gross vehicle weight rating that is not more than 20,000 pounds. Towing. You're not towing. Here's an example of a Texas driver's license. And also, this document is available for free download on the website. Here's a copy of a Texas driver's license. Class C, single or combination vehicle with gross vehicle weight rating 26,000 pounds or less, which transport place carded hazmat or 16 passengers or more, including a driver. Restriction, none. Endorsement, none. Under 522. 522. Section 522.041. Classification. D. Class C covers a single vehicle or combination of vehicles not described by Section B or C, that is, designed to transport 16 passengers, including the driver, or used in transportation of hazardous materials that require the vehicle to be place carded under 49 CFR, Part 172, Subpart F. 16 passengers, including the driver. 16 passengers, including the driver. Class C commercial driver's license. Okay?
Can I get your name and your badge number, please? Can I get your name and your badge number, please? For the record, this is for the record. What is your name and your badge number?
You said what?
For the record, what is your name and your badge number?
Deputy Chapel,
What is your...
7788.
Okay, am I being
Let
detained?
me see your driver's license and insurance.
For what reason?
Because you don't have a tag at the back.
I don't have to have one.
You don't?
No,
Why not?
because I'm not driving under commerce.
Because you what?
Section 521.025. License to be carried and exhibited on demand. Criminal penalty. A person required to hold a license under Section 521.021 shall 1. Have in the person's possession while operating a motor vehicle the class of driver's license appropriate for the type of vehicle operated, and 2. Display the license on demand of a magistrate, court officer, or peace officer. B. A peace officer may stop and detain a person operating a motor vehicle to determine if the person has a driver's license as required by this section. Now, I cannot exhibit a driver's license because the driver's license is not appropriate for the type of vehicle that is being operated, if you will. This Class C driver's license is authorized the individual to operate a Class C single combination vehicle, gross vehicle weight rating of less than 26,000 pounds, which transports place carded hazmat or carries 16 passengers or more, including the driver. One cannot produce a Class C driver's license under 521, being that the vehicle is not towing. The officer is asking the man to exhibit a Class C commercial license as though he were in person carrying at least 16 passengers or place carded hazmat. Remember, there are only 2 Class Cs, one under 522 and one under 521, which would be towing, basically for tow trucks.
Not under commercial capacity.
Are you an officer?
No, what are you pulling me over for? What is the arrest? Am I being detained?
You don't have a tag at the back of the vehicle.
I don't.
That's why I want the officer.
This is not a vehicle.
Okay.
Where's your sergeant?
So you don't have a driver's license or...
Where's your sergeant?
They're on the way.
Okay, I've been through this already. Sergeant Scott, I believe.
No, it's not Sergeant Scott.
I believe one of them. This same area.
That's fine. They on the way.
Okay.
So you're not going to show me your driver's license?
I'm gonna ask you, do I have to? Okay.
Questions. Why is it so important for an officer to ask an individual to exhibit a commercial driver's license? Answer. State courts can only adjudicate CDL cases. The agency cannot regulate non-CDL cases. Let's read. National District Attorney Association. The National District Attorneys Association represents state prosecuting attorneys who are responsible for prosecuting criminal violations in every state and territory of the United States. Both the National District Attorneys Association and the National Center for State Courts offers training for prosecutors and district attorneys on commercial laws governing commercial motor carriers and commercial drivers. Educators are available on limited basis to visit states to assist in training in CDL adjudication. The National Traffic Law Center, NTLC, also supports education and training regarding commercial vehicles intended for prosecutors. It is important for prosecutors to develop a working knowledge of the commercial driver's license laws. Although the terminology and regulation may be unfamiliar or confusing, understanding the basics about commercial motor vehicle and commercial driver's licenses is fundamental to effective investigation and prosecution of these cases. Given the size and power of commercial motor vehicle, knowledge of these laws will ensure their safe operation and save lives. Knowledge truly is power in the courtroom, and a basic understanding of commercial vehicle regulations will provide the tools needed to successfully resolve both traffic and non-traffic related cases. In addition, state court reporting of traffic convictions of CDL holders to state driver license agencies. State courts, judges adjudicate the facts of the case and apply the appropriate state law. If a judge finds that a CDL holder has committed an offense, the state court system transitions from adjudicatory function to an administrative reporting function, a task typically performed by personnel in a clerk's office or a court administrator's office. So once they adjudicate and find the facts, and there wasn't any rebuttal to their facts, then it transitions from an adjudicatory function to an administrative reporting function. Then they're going to report you to their employer. Okay? Administrative. Administrative connotes of or pertains to administration, especially management, as by managing or conducting, directing, or superintending the execution, application, or conduct of a person or thing. Administration, management, or conduct of an office or employment, the performance of the executive duties of an institution, business, or the like. Remember, once the judge adjudicates the facts, it turns into an administrative reporting function. Okay? They're going to report you to your employer. And who is your employer? Your employer's responsibilities. Question 1. If an individual driver had 2 convictions for serious traffic violations while driving a CMV, and neither the FMCSA nor his or her state licensing agency took any disqualification actions, does the motor carrier have any obligation under the Federal Motor Carrier Safety Administration regulations to refrain from using the driver for 60 days? If so, when does that time period begin? Guidance. No. The motor carrier responsibility under 383.37a to refrain from using the driver begins only when it learns of a disqualification action imposed by the Federal Motor Carrier Safety Administration or the state agency and continues until the disqualification period set by the state or Federal Motor Carrier Safety Administration is completed. A driver is an employer, a driver is an employee of their employer. Who is the employer? The motor carrier. Okay? A driver is employed by a motor carrier. Okay? Motor carrier. Administration. Administration, management, or conduct of an office or employment. Drivers. Drivers are employees of the Federal Motor Carrier Safety Administration. Okay? A. Drivers, as defined for Motor Carrier Act jurisdiction, 49 CFR Parts 390 through 395, is an individual who drives a motor vehicle in transportation which is within the meaning of the Motor Carrier Act in interstate or foreign commerce. As to what is considered transportation in interstate or foreign commerce within the meaning of the Motor Carrier Act, see subsection 782.7. 782.7 Interstate Commerce Requirements of Exemption. What constitutes such transportation in interstate or foreign commerce sufficient to bring such an employee within the regulatory power of the Secretary of Transportation under Section 204 of that Act is determined by definitions contained in the Motor Carrier Act itself. How does Transportation Code 522 relates to the Motor Carrier Act, 49 CFR Parts 390 through 395? Here's how. Section 522.005, Rulemaking Authority. The Department may adopt rules necessary to carry out this chapter and the Federal Act, and to maintain compliance with 49 CFR 383 and 384. Now, let's go to 49 CFR Parts 390 through 395. Federal Motor Carrier Safety Regulation, General. General applicability. The rules in subchapter B of this chapter are applicable to all employers, employees, and commercial motor vehicles that transport property or passengers in interstate commerce. B. The rules in Part 383 of this chapter, commercial driver's license standards, requirements, and penalties are applicable to every person who operates a commercial motor vehicle as defined in Section 383.5 of this subchapter in interstate or intrastate commerce, and to all employers of such persons. Again, rulemaking authority. Compliance with 49 CFR 383 and 384. There's your connection.
Hey, how you doing? Hey, how you doing, sir?
Here's my statement, brother.
The what now?
That's my statement.
That's your statement?
Yeah, and fill this out if you want me to answer any of your questions.
Okay, cool. Well, first of all, let me introduce myself to you.
What's your name and your badge number?
Huh?
For the record, what is your name and your badge number for the record?
Sir, I'm in the element. I can bet you got to speak up to me. If you don't want to roll down the way, you got to speak up to me.
What is your name and your badge number for the record?
Deputy Thomas.
What's your badge number?
8807.
Okay, 8807.
Deputy Thomas, Harris County Counsel's Office, Precinct 7.
Okay.
Okay.
How can I help? Am I being detained?
Yes.
For what crime?
Moving traffic violation.
For what crime?
That I'm not sure. This deputy pulled you over. I'm not sure what she observed.
Okay, so
first of all, let me speak to you for a second, okay? First of all, I'll make contact with you just to see what's going on. Okay? That's why I walked up and I introduced myself first of all. I haven't asked you for anything yet.
Gotcha.
You handed me this voluntarily.
Gotcha.
Correct? Okay. So if you don't give me a second, let me go through what you just handed me, okay?
Okay.
Okay, is it correct that you did request a supervisor?
No, she called the supervisor.
So what now?
She called the supervisor.
Okay.
I asked her where was her sergeant. I didn't ask. I didn't request one.
Okay, just sit tight for a second.
Okay.
More proof that they only can regulate commercial motor vehicles. Okay. The FHWA has reviewed its position and believes there is no need to regulate lightweight cargo carrying vehicles laden with non-hazardous property or small quantities of hazardous materials which do not require the vehicle to be place carded. In view of the foregoing, motor vehicles transporting non-hazardous property or quantities of hazardous materials which do not require place carding having a gross vehicle weight rating or gross combination weight rating of 10,000 pounds or less will not be subject to federal safety regulations. The American Bus Association opposes removing 15-passenger vans from the purview of federal safety regulations. It contends there is nothing in the statutory language or the legislative history to suggest that this was a congressional direction to FHWA to remove 15-passenger vans from regulation. There is a reference to small vans and pickup trucks being more analogous to automobiles than to medium and heavy vehicles, but the legislative language clearly refers to motor vehicles of property affected by the 10,000 pound limit. We seriously question whether Congress or any other authority would define a 15-passenger van as a small van. The gross vehicle weight rating of the Dodge and Ford 15-passenger vans are approximately 8,510 pounds and 9,100 pounds, respectively. The gross vehicle weight rating of the 12-passenger van manufactured by the Chevrolet division of the General Motors Corporation, the Dodge division of the Chrysler Corporation, the Ford Motor Company, or GMC Truck and Coach division of the General Motors Corporation range from 6,500 pounds to 8,500 pounds. The FHWA has historically regulated all commercial motor vehicles engaged in interstate commerce, although specific lightweight vehicles exemption have been allowed. Most vehicles having a gross vehicle weight rating of 10,000 pounds or less, having operating characteristics similar to a large automobile, and generally pose no greater safety risk than other vehicles of similar or lesser weight when used on the highway. Thus, the FHWA has long focused its activities on larger vehicles. In enacting the Motor Carrier Safety Act 1984, the Congress defined commercial motor vehicle to more clearly focus the federal resources devoted to motor carrier safety on medium and heavyweight motor vehicle. It specifically addressed the transportation of passengers and hazardous material and choose to limit application of the authority granted to the agency to issue safety regulations. Accordingly, the Act authorizes the issuance of safety regulations applicable to vehicles designed to transport more than 15 passengers, including the driver. Similarly, when the Congress recently enacted the Commercial Motor Vehicle Safety Act of 1986 to require implementations of a single classified commercial driver's license program, it defined the commercial motor vehicles to which the program would apply to include motor vehicles designed to transport more than 15 passengers, including the driver. This, too, then reveals the congressional policy of applying available federal motor carrier safety resources to larger vehicles. The FHA believes that Congress has clearly indicated its policy in this area, although the FHWA retains its authority to regulate lighter weight vehicles in the interest of safety. The FHWA does not believe that such federal regulations is warranted at this time. Existing accident data do not reveal that passenger vans used to transport 15 or few passengers in the interstate commerce require application of the federal motor carrier safety regulations to enhance the safety of their operation, nor do these data or other considerations reflect a need for federal enforcement of safety rules which are applicable to these operations. The FHWA believes that the safety regulation of these vehicles and their drivers can best be left to the state and local governments. For the reasons set forth above, the FHWA has decided to limit the application of the federal motor carrier safety to commercial motor vehicles as defined in Section 204 of the Act and as proposed in the NPRM. Thus, the federal motor carrier safety regulations will not apply to motor vehicles which have gross vehicle weight rating of 10,000 pounds or less, unless they are designed to transport more than 15 passengers, including the driver, and are used to transport hazardous materials in quantities requiring place carting. Designed to transport refers only to the number of designated seats. It does not include areas suitable or even designed for standing passengers.
What's going on, man?
How you doing?
Lay down your window. Let me talk to you. Hey, dude, she's trying to give you a warning citation. You have your driver's license on you.
What's your name and your badge number, first of all?
Excuse me?
For the record, can I get your name and your badge number?
Sergeant Michael J. Calvin.
Badge number?
714.
Okay, am I being detained?
You're not being detained.
Okay.
We want to see your ID because you committed a traffic violation. You don't have a license plate on your vehicle. And you know in the state of Texas, you got to have a license plate on your vehicle.
I agree, only if it was a vehicle. What give you the
I can't
presumption?
hear you, man.
I agree. What give you the presumption that there was a vehicle?
Excuse me?
What give you the presumption that this was a vehicle?
Sir, what else is it?
It's an automobile.
Okay, it's still considered a moving vehicle. You driving up and down the roadway.
No, have I been committed of a crime?
What?
Have I been committed of a crime?
Yes, you moving in violation with no plate on your vehicle.
That's
man.
a violation, not a crime, sir.
Sir, it's a traffic law in the state of Texas.
Okay, so she pulled me over pursuant to 543, correct?
Sir, It's a traffic violation. I'm not gonna go back and forth.
Okay, is this a custodial? Is this a custodial arrest?
No, it's not considered an arrest. You're being detained right now. But do you have your driver's license?
Okay, well, I want to invoke my 4th, 5th, and 6th
Retain.
Amendment right.
To retain as the possession of personality, to arrest, to check, to delay, to hinder, to hold, or keep in custody, to retard, to restrain from proceeding, to stay, to stop, to withhold. Custody. Detainment means to arrest. To detain means to arrest. Custodial arrest. Confinement or detention by police or government authorities during which a person is entitled to certain warnings as to his rights when questioned. Miranda versus Arizona.
What?
I want to invoke my 4th, 5th, and 6th Amendment right.
You can do that. But since you don't want an ID, we're going to take you in for failed ID then.
Okay.
All you got to do is give me your ID, man.
So,
this
hold
will
on.
be squashed.
So you saying you're going to take me to, hold on, for the record, you're going to take me to jail
Yes,
if I don't,
you are not, you refuse to give us your ID.
if I don't identify myself, you're going to take me to jail?
No, you identify yourself, but you're not identifying yourself.
No, hold on. I want to get it correct. You're going to, if I don't identify myself, you're going to take me to jail.
I'm going to have you taken in.
Okay, well, I'm going to identify myself under threat, duress, or coercion based on you saying you're going to take me to jail.
A driver is defined for Motor Carrier Act jurisdiction, 49 CFR 390 through 395. 49 CFR 390. The officer cannot induce a driver into operating a commercial motor vehicle. Here's proof. Coercion. 1. A threat by a motor carrier, shipper, receiver, or transportation intermediary, or their respective agent, officers, or representative, to withhold business, employment, or work opportunities from, or to take any adverse employment action against a driver in order to induce the driver to operate a commercial motor vehicle under conditions which the driver stated would require him or her to violate one or more of the regulations which the driver identified, at least generally, that are codified in 49 CFR 383. 390. Okay? It is against the law for any officer to take any adverse employment action against a driver to induce the driver to operate a commercial motor vehicle under conditions which the driver stated would require him or her to violate one or more of the regulations. Now pay attention in this next clip. And I'm going to state to the officer, whether he wanted to read it or not, I got him to read it.
Okay, I'm going to give you this, but I'm going to show you the back of my driver's license for the record that I'm not operating.
Just give me your ID, man. I'll read all that once I get there.
Okay, this is my back of my ID,
Okay,
my
where's
driver's
your
license.
ID at?
This is back of my driver's license, okay?
All right.
Okay. See that? I'm not driving what they say I need to be driving. You'll be making me committing an offense if I identify myself as driving that. That is the back of my driver's license. I do hold a driver's license, but I'm not going to give you that driver's license based on the fact that I'm...
See, you failing ID, man. Look, I done tried to be patient with you. All I'm asking you is for your ID. That's all you got to do is give me your ID.
I'm finna give it to you right here. Now, I'm holding you liable.
That's fine. You got my name and everything. You got my name and everything.
Okay.
All you got to do is give me your ID. here. You can have all
Let us read what the commercial driver's license prosecutor's guide have to say about it. The National District Attorneys Association created this document through financial support and assistance from the United States Department of Transportation, Motor Carriers Administration, Federal Motor Carrier Safety Administration, under grant number FMCDL 0202150100. NDAA is not part of the United States government, the United States Transportation, DOT, or the Federal Motor Carrier Safety Administration, FMCSA. Therefore, the National District Attorney Association does not represent the official position or policies of the Federal Motor Carrier Safety Administration, the United States Department of Transportation, or the United States government. We're going to stroll down to number 7, page 7. Does the driver need a CDL? Is the GVWR of the vehicle or vehicles more than 26,000 pounds? If yes, you go to the next question. If no, you go to the next question, and it reads, is the vehicle used to transport hazardous toxic material, which it should be place carded as classified by 49 U.S.C. 5103, 49 CFR Part 172, or 42 CFR Part 73, or designed to transport 16 or more passengers, including a driver? If that question, the answer to that question is yes, and if the answer to that question is no, then no CDL is required. Let's continue. Exemptions. Some vehicles, even very large vehicles, do not require the operators to hold CDLs. For example, vehicles used for recreational or non-business purposes do not require that the driver hold a CDL, although states may require the license. As discussed earlier, there are also exemptions in the federal regulations for certain military drivers, and states have authority to exempt certain farmers, firefighters, emergency response vehicle drivers, and drivers removing snow and ice. Okay? Non-business purposes do not require that the driver hold a CDL.
Okay, Mr. McCullough, here go your stuff back. Now you have a good day, sir.
All right, thank you.
Yeah, you good to go.
All right.